Since the Supreme Court decides such a small percentage of the cases that are appealed to it, attorneys, of course, are very curious for guidance to figure out what kinds of cases will the Supreme Court accept for review. And fortunately, the Supreme Court has given them a little bit of guidance in Rule 10 of Supreme Court Procedure, which purports to tell us what kinds of cases the court will accept. So let's take a look at Rule 10, which is divided into 3 sections. First, let's take a look at Rule 10, Section A. A United States Court of Appeal has entered a decision in conflict with the decision of another United States Court of Appeal on the same important matter, has decided an important federal question in a way that conflicts with a decision by a state court of last resort, or has so far departed from the accepted and usual course of judicial proceedings, or sanctioned such a departure by a lower court as to call for an exercise of this court's supervisory power. I invite you to pause this video and take a look at that, but let's boil it down, shall we? What does Section A really mean? Well, one of the things that it says is that the Supreme Court will be more likely to accept a case for review if there's a conflict between 2 or more U.S. courts of appeals. Oftentimes what happens is that 2 different courts of appeals will hear cases on the same legal issue, and they may come to the opposite conclusion. For example, when litigants were challenging Obamacare, they sued in several different states. And some courts of appeals declared Obamacare to be constitutional, some declared it to be unconstitutional. And of course, the U.S. Supreme Court needed to step in to resolve that conflict, to eliminate the confusion. Section A also says the court will be more likely to accept cases when they involve a conflict between the United States Court of Appeals and a state court of last resort, that is, a state Supreme Court. So conflict not only between 2 federal courts, but between a federal court and a state court will be more likely to get Supreme Court review, according to Rule 10. And then Section A also says they'll be more likely to review a case if a lower court got it really, really wrong. Now, of course, what is really, really wrong? There's no indication of that. But nevertheless, that's another thing that Section A says. But if you'll recall, we said earlier that the decision of whether or not to grant review in a case normally should be dependent on the importance of the case and not merely whether the lower court got it wrong. But as you can tell, essentially they're saying they have to get it really, really wrong, and I think they're trying to add in the importance with that qualification. So let's take a look at Section B. A state court of last resort has decided an important federal question in a way that conflicts with the decision of another state court of last resort or a United States Court of Appeals. So what does this say? Well, this is pretty similar to Section A. It says conflict between 2 or more state courts of last resort. So let's say the California Supreme Court and the Arizona Supreme Court have both decided cases that involved federal legal questions, and they arrived at different conclusions. The Supreme Court should be more likely to accept those cases for review. So as you can tell, so far the main theme is conflict between the lower courts. Finally, let's take a look at Section C. A state court or a United States Court of Appeals has decided an important question of federal law that has not been, but should be, settled by this court, or has decided an important federal question in a way that conflicts with the relevant decisions of this court. What does that mean? Well, Rule 10, Section C says that the Supreme Court will decide important cases. Now that's very interesting because if you'll recall, Rule 10 was supposed to tell us what kinds of cases are important. Well, what kinds of cases are important? Important cases. And it does not define important any better than that. It also says that it will be more likely to accept a case for review if a lower court has decided a case that conflicts with an existing Supreme Court precedent. So as you can see, conflict comes back up again. So what does Rule 10 mean when it's all summarized? Which cases, according to Rule 10, are indeed so important that the court will hear them? Well, Rule 10 tells us 2 things. 1. Cases that involve conflicts between lower courts, and 2. Important cases. And of course, number 2 is simply circular. Important cases are those cases that are important. So Rule 10 actually tells us absolutely nothing other than the court says it will be more likely to accept cases involving conflict. So the question is, or two questions come up. Number 1, there's a third criteria, cases in which the lower court really messed up. Cases in which the lower court really got it wrong. But again, this doesn't give anybody any guidance as to what those cases might be. So number 1 is really the only one that's specific at all. So attorneys, of course, have wondered, are there actually any patterns that we can look at that the court doesn't talk about in Rule 10? And I'm glad to say that political science has come to the rescue. Even though the Supreme Court will not tell you what kinds of cases it considers to be more important, political scientists have analyzed this. They've done a lot of statistical analysis, and we know exactly what kinds of cases the court finds more important and what kinds of cases they're more likely to grant review to. And in our next lecture, we will talk about that.